Hello, everyone. Will the Committee on Executive Matters and Legal Affairs please come to order? It's 1:04. I'd like to welcome committee members Say, Kia'aina, Wire, and Okimoto. The remaining committee members are excused for the purposes of at least beginning this meeting. Before we start the meeting, I have some procedural announcements to make. Pursuant to Section 92-3.7 Hawaii Revised Statutes, this meeting will be conducted as a remote meeting by interactive conference technology with the following procedures in effect for the meeting. Members of the public will be allowed to provide oral testimony remotely or in person in the council chamber on all items on the agenda when each item is taken up. All persons who registered to testify in person will be called upon first, followed by those who registered to testify remotely. Before testifying, each person shall state their name. Each speaker may not have anyone else read their statement and is limited to a 1-minute presentation on each item. For remote testifiers, when your name is called, please monitor your screen and activate your audio feed when prompted. For those who are joining us by telephone only, please press *9 to indicate your desire to speak. All registered testifiers will be called upon first, and then I'll give persons who have not registered an opportunity to speak following the oral testimonies of the registered speakers. Please utilize the raise hand feature in Zoom to be called upon. HRS Section 92-3.7 requires all votes at remote meetings to be conducted by a roll call unless unanimous. Therefore, if any objections are noted, I'll call for a roll call vote. For those council members participating from outside of the council chamber, in accordance with HRS Section 92-3.7, the meeting will automatically recess if we lose audiovisual contact with you and cannot reconvene until we reestablish contact. Therefore, please announce beforehand if you'll be voluntarily signing out of the meeting. Written testimonies, including the testifier's address, email address, and phone number, will be available to the public as described in the posted agenda. As a courtesy, please turn off all cell phones for the duration of this meeting. We're going to welcome Councilmember Tolba at this moment. Thank you. And we'll begin now with agenda item number 1, which is Resolution 23-239, which initiates amendments to the revised charter of the City and County of Honolulu, 1973, amended 2017 edition, as amended, relating to the qualifications of the Director of Emergency Management. Members, we do have a posted proposed CD1 submitted by Councilmember Wire. For your information, the summary of the amendments is listed on the agenda. We also have a proposed CD1 submitted by the department. For your information, the CD1 is available online as Departmental Communication D83. Councilmember Wire, would you like to give a summary of your proposed CD1, even though it is posted on the agenda?
Yeah, I mean, I would defer to the agenda, but just note generally that we have been working with DHR and DEM to, I think, be responsive to what they see as criteria they already have and not being overly burdensome, but also responsive to the community to ensure that we at least have some minimum requirements in the charter.
All right. Speaking of those departments, we do have the Director of Human Resources as well as the Director of Emergency Management here. If either of them would like to present some information to us, please feel free to do so.
Good afternoon, Chair Dos Santos Tam and members of the committee. Nola Miyasaki, Director of the Department of Human Resources. Thank you for this opportunity, and thank you to Chair and Councilmember Wire for working with us on these amendments. The changes that we've proposed are really to bring the language in alignment with our current minimum qualifications for the position as it exists now, and we believe that this is the appropriate criteria for this position. We had a couple other housekeeping changes, but this is the main change.
Thank you. And the Director of Emergency Management?
Yeah, good afternoon, Chair and members of the committee. Hiro Toya, Director of the Department of Emergency Management. I just want to say I just really appreciate being able to be a part of this process, and the communication and dialogue we've had with your office and also with Councilmember Wire has been really great in terms of being able to collaborate on this. And I think we all recognize that ultimately credibility is important for all of us that work in government, and having public trust in this position is paramount to the success of the department and also for public safety. And so just really appreciate the opportunity to introduce additional language to kind of codify the qualifications into charter and to put it to the voters to make this ultimate decision. So just echoing Director Miyasaki's comments, Councilmember Wire, appreciate the proposed CD1 and just some minor change to the language. And actually, it makes it a little bit more stringent and more in line with the current language that's contained in the class specification for the position. So I hope this is a good step forward in terms of codifying the qualifications of the positions into charter and to do it in a way that's going to be meaningful for the future. So thank you very much.
Thank you, members. Any questions for either director? Okay, seeing none, why don't we proceed with testimony? We'll proceed with in-person testimony. Clerks, do we have any in-person testifiers?
Chair, there are none.
Okay, is there anyone else in the chamber who'd like to testify? Okay, seeing none, clerks, do we have any registered remote testifiers or anyone standing by remotely to testify?
Chair, there are none.
Okay, there being none, members, I do want to acknowledge our committee vice chair Cordero for attendance at this meeting. And I'd also like to open up a discussion on this. Any discussion? Okay, I do, Councilmember Wire, this was your proposal. I don't know if you have any points you'd like to make for the committee.
Well, I was curious what the chair's inclination was, but just generally speaking, I think ultimately what this conversation has been about is, one, it's been a great opportunity to, just see how qualified our professionals are, and so we appreciate, the service, particularly of Emergency Management Director, and just understanding that going forward as a community, right? Like, we're only here for a brief moment in time, and so we just want to ensure that we have minimum criteria established in the charter to ensure that whoever's, leading the department in light of the increasing, disasters and storms and experiences the community is going to have, we just want to make sure that there's safeguards there, and so that's really what it's ultimately about. And really, as mentioned earlier, it's going to be up to the voters if they want to further amend the charter. I'm comfortable tweaking the language a little bit more, and of course it'd be up to chair and the committee, and so appreciate the opportunity.
Thank you. Well, if there's no other discussion, the chair's recommendation is going to be that we amend to the posted CD1 and then to Councilmember Wire CD1, and then the changes from the department we can do as an FD1 on the floor on the 28th. Because those are fairly minor, and I think that'll give us some final time to really tweak it before it gets to the voters. So the chair recommends that Resolution 23-239 be amended to the posted CD1, that is OCS 2024-0021, 1/9/2024, 8:20 a.m. And this is Councilmember Wire's proposal. Any discussion, objections, or reservations? Okay, hearing none, Resolution 23-239 is amended to the CD1, and then the chair then recommends the Resolution 23-239 CD1 will be reported out for passage on third reading. Any discussion, objections, or reservations? Okay, hearing none, so ordered. Thank you, members. We'll now move on to agenda item number 2, which is Bill 44 of 2023, which deters persons from making or inciting the making of a false statement to a public servant. Members, please note that we have posted to the agenda the CD1, which is OCS 2023-0743. That was approved by the Committee on Executive Matters and Legal Affairs at its meeting on August 22nd of 2023 and subsequently postponed in committee. Members, we also have a proposed CD1 to the bill submitted by myself. For your information, the summary of those amendments is listed on the agenda addendum. Do we have the Director of Permitting and Planning? Okay, very well. We'll proceed now with in-person testimony on this. Clerks, do we have any in-person testifiers or anyone in the chamber who'd like to testify? I see we have registered Jody Patarai and then Jolie Tokusato. So if Jody's here and then Jolie. Okay, Jolie, please come on up then. And then anyone else in the chamber who'd like to testify can follow Jolie. And Jolie, if you press the button on the right side.
Yes, okay. Unite Here, Local 5, representing 10,000 working people in hotel, food service, and healthcare industries across Hawaii. We are in support of Bill 44, CD1, as proposed by Chair Dos Santos Tam. This measure would create meaningful penalties for developers of monster homes seeking to sneak projects through the permitting process. The current practices of some unscrupulous monster home developers are detrimental to our communities and to those who ultimately live in those structures. The amendments proposed in CD1 help ensure that it is not applied too broadly and in unintended ways. Monster homes are a problem for our communities. They put stress on infrastructure without taking steps to mitigate it and without giving the city and county the ability to plan appropriately for it. The intensity of use they bring with them can create problems in residential neighborhoods, problems with parking, traffic, and utility usage in the short term, and in the long term, their aggregate impact could require the city to undertake costly infrastructure upgrades to increase the capacity for the sewage, electric, water, roadway, police, fire, I'm almost done, and other systems. The development of residential units on Oahu needs to be done in a conscious, coordinated way. If not, it is the public who will ultimately pay the price in more ways than one. Thank you for letting me testify.
All right, members, any questions for the testifier? Okay, seeing none. Anyone else in the chamber who'd like to testify, please come forward.
Hello, my name is Sarah Chinen, and I was in the fight against monster homes, and they still came up. So thanks to Tyler Dos Santos and Tommy Waters and all you guys, well, you guys weren't there yet, but they're kind of slowed down, but they lie. And maybe that's their culture, and I'm supposed to be politically correct, but I think if they lie and they affect our neighbors and neighborhoods the way they have been, then the penalties should be really severe, like export them. But anyway, I think lying to inspectors is really, really wrong because it really destroys our lifestyle. So thank you.
Thank you, members. Any questions for the testifier? Okay, hearing none, clerks, is there anyone else in the chamber who'd like to testify?
Chair, there are none.
And then clerks, do we have any registered remote testifiers or anyone standing by remotely to testify?
Chair, there are none.
Okay, there being none, members, I do see the Director of the Department of Permitting and Planning. If she'd like to present some comments on the bill.
Thank you, Chair. With this bill, we completely understand the issue with monster homes and the ability to deter people for designing and erecting monster homes in violation of the LUO. This bill, we do have some concerns with it, as far as I think it begins with the basic assumption that you would need a conviction for this crime, and to establish mens rea of that someone knew that they were falsely making this statement, or that would be probably difficult to determine and should involve the prosecutor's office and their ability, their capacity to get a conviction. So I think actually getting a conviction for this type of crime would probably net few and far between. And then if there were convictions, the application of the penalties and the issues regarding temporary certificates of occupancy, I understand that, you would want to issue these penalties to the person that made the false statements, but there's different parties involved other than, say, the architect, the design professional, or the applicant, the landowner themselves. So there might be someone, a landowner who wants to build the structure, but are you applying this to the landowner or the designer? There's different parties involved. I think, and we do have, another bill before the council that directly increases the fines greatly for those that violate the monster homes ordinances. But we do like the increase in fines under 18.7.4. I think it goes from 2,000 to 3,000, which provides more teeth for us to enforce. But again, we do have concerns with the getting the criminal conviction and who the penalties would apply to. Thank you.
Okay. Members, any questions for the director? Okay, Councilmember Cordero and then Tolba.
Thank you, Director. That's a great point relating to whoever would be responsible for the violations. And a lot of the times, and I've heard this from a few neighborhood board members, is relating to the violation is sometimes mainly done by contractors. Do you have a recommendation on whom we should specify?
Well, I guess, to clarify, it would have to be the person that was convicted, but a new project where some of the penalties for disallowing, I guess, building permits, et cetera, it involves all those different parties. So even though you have someone that's been convicted of false statements, the architect, you may have the contractor doing the building not according to plans or not up to code. So there's many different parts to this, and I'm not sure if this will necessarily address the right party or, especially going forward.
Okay, so you don't have any actual specific recommendations on who to specify?
I guess it's just, I think it's going to be obviously the person that's been previously convicted, but I don't know if it will necessarily address going forward the correct parties, because it might be a different party or,
Okay, thank you. Thank you, Chair.
Thank you, Councilmember Tolba.
Thank you, Chair. Director Puna, under the proposed City 1 ROH 18-6.1 and 18-6.2 would be amended to allow a building official to increase the fees of an applicant with the history of making false statements. So how would this work, in practice? Like, for example, if someone would be automatically applied, would this practice continue against the person indefinitely? Are there norms or parameters to help the building official administer this without being seen as unfair or biased?
So those are good questions. I think looking at how we would administer something like this, we would have to have notice that there is a standing or a conviction. And from there, I guess that's how we would kind of notate in our own records that we would proceed under what is required under the bill. But you bring up a good point as far as not allowing someone to build or get a building permit. I think there are certain rights to do that, which I don't necessarily believe a conviction for a false statement can deny that right to move forward with building a structure or applying for a permit.
Thank you, Chair.
Thank you. Chair Waters, and then Councilmember Wire.
Thank you. One of the things I talked about since I was first elected was having a checkoff box in the building permit saying that I, as the applicant here, do attest under penalty of law that my application is true and correct. Any thought to that idea?
Yeah, I think we've actually looked at that too. I think that's a good idea that, you're attesting to what you're putting forth as part of the application, and then if it doesn't pan out that way, that we have that in writing and signed.
Okay, any idea when or if you're going to implement that idea?
I think we did have some language that I think I got to go back and see if how we can implement that.
Okay. I did watch the trial of before the Building Board of Appeals on the home in Sierra Drive, where the drafter was not an architect, but a draftsman, who claimed that the portion of the home that basically was enclosed by 3 walls and a ceiling didn't count towards the FAR. Would that be considered a false statement under state law?
Yeah, so I think that that's another good point. It might not be a false statement, but it's just an inaccurate statement that it was just still wrong, but we can't prove that it was, that they, lied about it. It wasn't accurate. It wasn't a correct statement to make.
I know you're saying that the use of this ordinance may be few and far between, but does your department contemplate the situation where someone does make a false statement, that you'll turn it over to the prosecutor's office for possible prosecution?
Yes, I think case by case, we look at it and we believe that they are, they're falsely making certain statements in their application, that we have that avenue to turn it over to the prosecutor's office.
What would qualify, in your opinion, as a false statement?
I think so. Some of it is with, say, the Sierra Drive, where they say that their FAR on the title sheet was below the standard or the threshold, but then when you look at the calculations on the plans, that it doesn't add up to that FAR, it exceeds it. But that too, it's difficult to say whether it's a false statement as opposed to just an error or inaccuracy on their part.
Right. Good points. Thank you very much. Thank you, Chair.
Thank you. Councilmember Wire.
Thank you, Chair. And Mahalo, Director, for sharing your insight. I understand the concerns. I just wanted to clarify, though, or make sure, based on what I'm interpreting or reading, is it your understanding that DPP would still retain discretion in applying these terms?
I think that if we get notice that there was a conviction on, then we could work through the process that's spelled out in this ordinance. So I mean, it just all hinges on a conviction, a criminal conviction.
Okay.
Yeah, but that too, I think the work and the involvement from DPP to establish a conviction, that's a lot of resources on our part to, and I think it's difficult. It's definitely more difficult to establish than I think in the other bill that we're offering, where we're just saying if you violate the provisions of the Monster Home Ordinance, then you're subject to a much higher fine.
No, I appreciate that. But is your understanding that the bill doesn't necessarily create like any affirmative duty on DPP's part? It's just a tool that could be used if a conviction's achieved? And I just want to clarify, because I want to make sure, like, obviously I know you're stretched super thin,
Right.
and we're wanting to give tools and not necessarily distract from other work, but it sounds like this would kind of just be in place in case it's ever needed or useful.
Yes, I think that's correct. Yeah, if we get a conviction for this, then we could say, okay, in this instance, we would have to do this, or we could do this and the other, or we should.
Okay. Okay, appreciate that. Mahalo. Thank you, Chair.
Thank you, members. Any other questions for the Director? Director, I have just a few questions. With regard to Chair Waters' question about the box or attestation that somebody's in compliance and doesn't have this history, I know that we just discussed last year, I think it was Bill 36, which tried to eliminate one of those boxes, but in that hearing, we were assured that DPP has these internal processes to vet this. That still remains the case, right?
Yes, so I think the affidavit that you're speaking of in another bill, so the affidavit, it's a separate affidavit requirement, a separate paper that would say that they do not have any outstanding NOVs or NOOs, that would be separate and different than on the actual building permit application, that you're saying that whatever I'm submitting is true and correct.
Okay. And then, speaking of another bill, I know Bill 52, which is, I think, the bill you alluded to earlier, which raises the fines for violators of our large detached dwelling ordinance. A DPP recently submitted a request for extension of time. Could you sort of recap why we need more time on that bill?
I would defer to the zoning chair and that committee. I think it's a scheduling issue. Yeah.
Okay. And then finally, we did talk about the instances where, perhaps there is an error in the calculations or something like that. Is that a common occurrence in your experience?
Errors in plans are a very common occurrence.
And then has there ever been an instance where somebody's accidentally overstated their FAR?
Possibly. Yeah, I'm sure they have, but yeah, I don't know.
I guess the challenge is we always find people trying to get under the regulations, and if it were truly an error, you'd think half of them would be overstating it and half of them would be understating it.
That's true, yeah.
But okay, thank you, Director. Members, last call for questions. Okay. We did do testimony on this, right? So at this point, we'll open up for discussion. Members, any discussion on this bill? Vice Chair Kiana.
Thank you, Chair, for continuing to work on this measure. I know many of us are interested in deterring developers that provide false information to DPP in order to construct properties in violation of existing city laws. Given the limitations of Bill 44 and concerns over preemption, I hope that while we continue to make progress on this measure, that we continue to look at heftier penalties for developers that lie on their plans or convert rooms during constructions, such as those found in Bill 52, 2023, that is being considered in the zoning committee. Thank you so much.
Okay, thank you. Members, any other discussion? Floor Leader Cordero.
Thank you, Chair. I just really want to highlight what my colleague, Councilmember Wire, mentioned about this bill being another tool for DPP to utilize at their discretion. So I really hope that we can find a way to shore it up to be used by DPP. So in full support of that.
Thank you. Any other discussion? Okay. The chair recommends that Bill 44, 2023 be amended to the posted proposed CD1, which was OCS 2024-0082. Any discussion, objections, or reservations to that recommendation to amend? Hearing none, Bill 44, 2023 is amended to the CD1. Chair then recommends that Bill 44 of 2023 CD1 be reported out for passage on third reading. Any discussion, objections, or reservations? Thank you. Hearing none, so ordered. Thank you. All right. We'll move on to agenda item number 3 in this case, which is Resolution 24-25, which establishes a sister city relationship with Rarotonga, Cook Islands. Members, we do have a hand-carried CD1 to the resolution submitted by myself. The CD1, OCS 2024-0101, makes the following amendments. A, it amends the second be it further resolved clause and the be it finally resolved clause to remove Rarotonga from the Prime Minister's title, as the Prime Minister is the Prime Minister of the Cook Islands. And then B, it makes miscellaneous technical and non-substantive amendments. We do have the Executive Director of the Mayor's Office in Culture and the Arts here to share her manao on this resolution.
Aloha Chair Dos Santos and council members. Ka'ili Trask O'Connell, Executive Director of the Office of Culture and the Arts. I'd like to express my support for Resolution 24-25, introduced by the Mayor's Office of Culture and the Arts. This resolution seeks to establish a sister city relationship with Rarotonga Cook Islands. Rarotonga and its surrounding Cook Islands are a culturally rich set of islands with communities that share similar values and interests with the people of Honolulu. The recent expansion of transportation between Honolulu and Rarotonga will strengthen economic opportunities of both our cities. Rarotonga and Honolulu both proudly treasure their island's natural resources and are committed to preserving them through regenerative tourism initiatives. This priority focus is another area that our cities can collaborate on. There are many opportunities for Rarotonga and Honolulu to partner and learn from each other, including business, environment, education, and again, tourism. Finally, Sister Cities International recently launched their 7 for 70 initiative, which commits to creating 7 new sister city relationships in the Pacific Islands by 2026 in celebration of their 70th anniversary. So we see this as an ideal opportunity to be partnering with Rarotonga. Should Resolution 24-25 be adopted, our hope is to host the Rarotonga and the Honolulu Sister City signing at FestPAC here in Honolulu in June 2024. Thank you for your consideration.
Mahalo, members. Any questions? Vice Chair Kiaina.
First, I wanted to thank Mayor Blangiardi as well as yourself for cultivating this sister city relationship, Rarotonga, which I strongly support. So you just stated that you are looking at implementing this agreement between the Prime Minister and the Mayor during FestPAC. Is there any reason we have to wait that long? Because, you know, there's going to be a lot of activities going on during that time frame. People's times are going to be pulled. You know, all it has to do is pass full council, and then a ceremony could be done. Did the Cook Islands request that it be?
Yes, they're excited about the opportunity as well. It would be mostly ceremonial at FestPAC. We would still go through the process and get to that point, but we thought it'd be a perfect time at FestPAC since we're celebrating the cultures of the Pacific Islands.
Oh, no, I fully understand that. I'm just telling you that there's going to be a lot of activities going on. It's
understood, yes.
Be overshadowed. Okay, and then my other question has to do with the city's efforts to further strengthen relationships throughout the Pacific. Cook Islands is in Polynesia, so that's terrific. Polynesian sisters. What efforts are going to be undertaken to look into having a sister city relationship in Micronesia or Melanesia?
Well, currently our focus is on Rarotonga, and we are open to ideas for other Pacific Island cities.
Well, I'm recommending that, that you look at other areas and, you know, just as a matter of equity, right? We're all about equity here. Try to diversify and look at a place in Melanesia or a place in in Micronesia. I do know that the chair and I have discussed strengthening ties with the Marshall Islands. I believe they may have had a sister city relationship, and we probably need to revitalize that. But I guess I just want to encourage your office as well to also think about how we could look at other areas to have ties.
Understood.
I support the overall sister city relationships, but I have believed that there is an overabundance of focus on Asia and certain countries in Asia. And, you know, what these type of relationships could do with proportionately smaller islands, culturally and economically, and just, you know, with regard to sustainability, the issue of sustainability, which you highlighted in the resolution, could go a long way. And I feel that beyond just being symbolic, the relationship with them could be far more deeper and impactful to the quality of life for those areas than some of our current ones. So I just wanted to make that statement. Thank you so much.
Thank you very much.
Members, any other questions? Chair Waters.
I guess not so much a question, more just a comment that thank you very much for putting this all together. My friend Tapo Worthington is here today, but it's so important to learn from our sister cities. And from what I've learned from my friend is that in Rarotonga, just the way the government works, it's really fantastic. And I'm hoping he talks about that today, because we government officials can actually learn from them as well. So appreciate you. Thank you.
Thank you.
Thank you, members. Any other questions? Okay. Hearing none, thank you. Why don't we open it up to testimony? We do have one registered testifier, Teonaroa Pacha Worthington. And when you get up to the microphone, press the button on the right side.
Kia ora ana, aloha no kako from Rarotonga. My name is Te Anaroa Paka Worthington. I'm in a unique situation because I am part Hawaiian, but I also am part Rarotongan and Tahitian too. So I spent a lot of time in Hawaii and a lot of time in Rarotonga, so I know both places quite well. Just so you do know, we all talk about the Polynesian Triangle. As we know, Hawaii is at the top in the north, Aotearoa is at the south. We have Samoa at the west and Tahiti in the east. In Rarotonga, we call it the pito. We are right in the middle. We are the belly button of Polynesia. So we have very strong relationships with Aotearoa, Samoa, and Tahiti, not so much with Hawaii, which is partly why we're here supporting this resolution. We mentioned that some of the commonalities and issues between us is Hawaiian Airlines just started a direct flight from Honolulu to Rarotonga in May of last year. So seeing the commercial and economic success of that is very important to us, and of course to Honolulu as well too. We mentioned sustainable and regional regenerative tourism, another big issue for us. A lot of the issues that we're dealing there are a lot of the exact same issues because we're all small island governments and nations. I'll just quickly go through the other ones. Being the environment, we actually have the largest marine protected area in the world at 750,000 square miles, very similar to Papahanaumokuakea as well too, and I could see some commonalities there. There's deep sea mining, fisheries, offshore banking is a big issue there. We do with a lot of people from the United States, agriculture, education, exchange student programs, and of course culture with the PACFest coming up in June. I'll stop there.
Okay, members, any questions? Okay, hearing none, thank you. Oh,
I'm sorry. No,
Vice Chair
just make some comment, and after I finish, I just want to make some statements, but feel free to elaborate a little more, because we rarely get any opportunity to learn about the Pacific, including the Cook Islands, so feel free to continue talking about it. But let me just make some comments first. I wanted to thank you personally, and just for transparency purposes, I've known Paka for a long, long time. When I first started off my career in Washington, D.C., he was a freshman at American University. And so I was very close to both him and his family. So I wanted to thank you personally for your commitment to strengthening ties between Rarotonga and the city and county of Honolulu. And I also wanted to acknowledge the contributions of your late father, Bob Worthington, who served as an honorary consul for the Cook Islands to the United States for over 35 years, living here in Hawaii. And I just wanted to say he was a remarkable and visionary leader, and I considered him a good friend, and I miss him very much. I look forward to you continuing in his footsteps and you personally interjecting your own mana and experiences to making this sister city relationship with Rarotonga a thriving one. So I just want to personally thank you for this, because you were one of the main reasons behind why this was happening. I also wanted to credit Sam Moku, who did a lot of the due diligence to get this done. So thank you.
Thank you for acknowledging my father as well too. I will just say a couple of quick things. I am not here representing the government of the Cook Islands. I am just here as a citizen of the Cook Islands and a citizen of Hawaii. I will just briefly say this to you people. You'll be very interested to know that we have no homeless people in the Cook Islands, nobody on the street, nobody begging for money. We have free health, free education, free dental. And with people who know about the Pacific, I can say that in terms of the standard of living and what we have there, and then get this, no real estate taxes either. And we, in terms of the Pacific Islands, in terms of economic development and standard of living, we are number one. And so We have a bank there that specifically does banking for local people as well too. So I've had some people from Hawaii come to the Cook Islands and look around what's going on, and we're quite shocked and surprised of the way that we run our government down there. So it's quite interesting.
Thank you. Members, any other questions? Okay, hearing none. Clerks, is there anyone else in the chamber who'd like to testify?
Chair, there are none.
And then clerks, are there any registered remote testifiers or anyone standing by remotely to testify?
Chair, there are none.
Okay, members, we are in discussion. Any further discussion, members? I do want to thank Vice Chair Kiainu, and I know she's very familiar with the Pacific Islands, for bringing up Majuro, which we've had a relationship with for about 14 years. We actually planned to do a 10-year anniversary with them, but that was right before COVID, and that short-circuited everything. And I think it would be high time to do a little ceremony with them and really reinvigorate that relationship as well. So maybe we can work with the MOCA director on that. Okay. Any further discussion? Okay, hearing none, the chair recommends a resolution 24-25 be amended to the hand-carried CD1. Any discussion, objections, or reservations? Okay, hearing none, resolution 24-25 is amended to the CD1. The chair then recommends a resolution 24-25 CD1 be reported out for adoption. Any discussion, objections, or reservations? Hearing none, so ordered. Members, we do now move to executive session. The following items as posted on the agenda have been referred to executive session. I'll read the items individually to allow for oral public testimony on each item. The first is a request for authorization to settle a case against Cheryl Sunia, a former employee of the City and County of Honolulu, in Roynes J. Dural II versus City and County of Honolulu et al., civil number CV21-00461 HGWRP USDC. Clerks, do we have any in-person testifiers or anyone in the chamber who'd like to testify, or any remote testifiers, or anyone standing by remotely to testify?
Chair, there are none.
Okay. In that case, we'll move on to agenda item number 5, request for authorization to settle a case against defendants, City and County of Honolulu and Susan Ballard, in Deborah Lynn Thomas individually and in her capacity as personal representative of the estate of Kyle Thomas versus City and County of Honolulu et al., civil number CV21-00087 JAO-KJM USDC. Clerks, do we have any in-person testifiers, anyone in the council chamber who'd like to testify, registered remote testifiers, or anyone standing by remotely to testify?
Chair, there are none.
Okay, very well. We'll move on to number 6, which is the request for authorization to settle a case against defendants Ronald V. Dumlau, Chance C. Correa, and Jose J. Villanueva in Deborah Lynn Thomas individually and in her capacity as personal representative of the estate of Kyle Thomas versus City and County of Honolulu et al., civil number CV21-00087 JAO-KJM USDC. Clerks, do we have any in-person testifiers, anyone in the chamber who'd like to testify, any registered remote testifiers, or anyone else standing by remotely to testify?
Chair, there are none.
Very well. We'll move on to number 7, which is a resolution to retain the legal services of Kobayashi Sugita and Goda LLP as Special Deputy Corporation Counsel for the City and County of Honolulu on behalf of Petitioner, Director of Budget and Fiscal Services, City and County of Honolulu, in a legal action entitled The Estate of Richard Lee Jackson, P number 12-1-0425 Circuit Court. Clerks, do we have any in-person testifiers, anyone in the chamber who'd like to testify, any registered remote testifiers, or anyone standing by remotely to testify?
Chair, there are none.
Okay, that being the case, we'll move on to number 8. This is a request for authorization to settle a lawsuit against the City and County of Honolulu entitled Association of Unit Owners of Leo Townhouse by its Board of Directors versus City and County of Honolulu, civil number 1 CCV-22-0001207. Clerks, do we have any in-person testifiers, anyone in the chamber who'd like to testify, any registered remote testifiers, or anyone standing by remotely to testify?
Chair, there are none.
Okay, that being the case, we'll move on to number 9. This is a resolution to amend contract number SC-COR 230-0086 to request additional funds to continue the services of McCorston, Miller, Mukai, McKinnon LLP as special counsel to represent defendant Jake Bartolome in the related legal actions entitled Uolani Gavea et al. First City and County of Honolulu et al., civil number 1 CCV 21-00011150, Matthew Tabag-Kalua et al. Versus City and County of Honolulu et al. 1CCV-22-00000415, and Jonathan Perkins Sinapati et al. Versus City and County of Honolulu et al. Civil number 1CCV-22-00000429 Circuit Court, and to allow the representation of defendant Jake Bartolome in Uolani Gavea et al. Versus Rick Blangiardi et al. Case number 1CV-23-00378 JAO-WRP USDC. Clerks, do we have any in-person testifiers? Anyone in the chamber who'd like to testify? Any registered remote testifiers, or anyone standing by remotely to testify?
Chair, there are none.
Okay, we'll move on to agenda item number 10. This is a resolution to amend contract SC COR 2300087 to request additional funds to continue the services of Kobayashi, Sugita, and Goda LLP as special counsel to represent defendant Eric Smith in the related legal actions entitled Uolani Gavea et al. Versus City and County of Honolulu et al. Civil number 1CCV-21-00011150 Matthew Tabag-Kalua et al. Versus City and County of Honolulu et al. 1CCV-22-000415 and Jonathan Perkins Sinapati et al. Versus City and County of Honolulu et al. Civil number 1CCV-22-00000429 Circuit Court, and to allow the representation of defendant Eric Smith in Uolani Gavea et al. Versus Rick Blangiardi et al. Case number 1CV-23-00378 JAO-WRP USDC. Clerks, do we have any in-person testifiers? Anyone in the chamber who'd like to testify? Any registered remote testifiers, or anyone else standing by remotely to testify?
Chair, there are none.
Okay, and then we'll move on to the final executive session item. This is a request for authorization to settle claims against the City and County of Honolulu by Stephen Bowes. Clerks, do we have any in-person testifiers? Anyone in the chamber who'd like to testify? Any registered remote testifiers, or anyone else standing by remotely to testify?
Chair, there are none.
Okay, hearing none, members, are there any objections to convening into executive session? Without objection, the committee convenes into a closed meeting pursuant to Hawaii Revised Statutes, Section 92-4 and 92-5A4, to consult in a closed meeting with its attorneys on questions and issues pertaining to the powers, duties, privileges, immunities, and or liabilities of the city, the council, and its committees on the items listed on the agenda for executive session. The following persons will be participating in executive session: all council members present. From the Office of Corporation Counsel, Dwayne W.H. Pang, Paula Aoki, Richard Llewellyn, Juana Yost, David Minkin, Jordan Inafuku, Thomas Nafziger, Don Sugihara, Lex Smith, Paige Ogata, and Kathleen Kelly. We'll also be joined by Seichi Liu, Office of Council Services Staff Attorney. I'll now call a recess. Thank you. The Committee on Executive Matters and Legal Affairs is reconvened. It's 2:27 p.m. Pursuant to Section 92-4 and 92-5A4 Hawaii Revised Statutes, the committee has consulted in executive session with its attorneys on questions and issues pertaining to the powers, duties, privileges, immunities, and reliabilities of the city, the council, and its committees on items listed on the agenda for executive session. I'll now make my recommendations on the executive session items. The chair first recommends that the request for authorization to settle a case against Cheryl Sunia, a former employee of the City and County of Honolulu, in Royns J. Durald II versus City and County of Honolulu et al., civil number CV21-00461HG WRP USDC be approved. The chair secondly recommends that the request for authorization to settle a case against defendants City and County of Honolulu and Susan Ballard in Deborah Lynn Thomas individually and in her capacity as personal representative of the estate of Kyle Thomas versus City and County of Honolulu et al. Civil number CV21-00087 JAOKJM USDC be approved. The chair thirdly recommends that the request for authorization to settle a case against defendants Ronald V. Dumlau, Chance C. Correa, and Jose J. Villanueva and Deborah Lynn Thomas individually and in her capacity as personal representative of the estate of Kyle Thomas versus City and County of Honolulu et al. Civil number CV21-00087 JAO-KJM USDC be approved. The chair fourthly recommends that resolution to retain the legal services of Kobayashi Sugita and Goda LLP as Special Deputy Corporation Counsel for the City and County of Honolulu on behalf of petitioner, Director of Budget and Fiscal Services, City and County of Honolulu, in a legal action entitled The Estate of Richard Lee Jackson, P number 12-1-0425, Circuit Court be approved. The chair fifthly recommends that the request for authorization to settle a lawsuit against the City and County of Honolulu entitled Association of Unit Owners of Leo Leo Townhouse by its Board of Directors for City and County of Honolulu, civil number 1CCV-22-0001207 be approved. The chair sixthly recommends that the resolution to amend contract number SC-COR-2300086 to request additional funds to continue the services of McCorston Miller Mukai McKinnon LLP as special counsel to represent defendant Jake Bartolome in the related legal actions entitled Uolani Gavea et al. Versus City and County of Honolulu et al. Civil number 1CCV-21-001150 Matthew Tabag Kalua et al. Versus City and County of Honolulu et al. 1CCV-22-0000415 and Jonathan Perkins Sinapati et al. Versus City and County of Honolulu et al. Civil number 1CCV-22-0000429 Circuit Court, and to allow the representation of defendant Jake Bartolome in Uolani Gavea et al. Versus Rick Blangiardi et al. Case number 1CV-23-00378-JAO-WRP USDC be approved. The chair seventhly recommends that resolution to amend contract number SC-COR-2300087 to request additional funds to continue the services of Kobayashi Sugita and Goda LLP as special counsel to represent defendant Eric Smith in the related legal actions entitled Uolani Gavea et al. Versus City and County of Honolulu et al. Civil number 1CCV-21-0001150 Matthew Tabag Kalua et al. Versus City and County of Honolulu et al. 1CCV-22-0000415 and Jonathan Perkins Sinapati et al. Versus City and County of Honolulu et al. Civil number 1CCV-22-0000429 Circuit Court, and to allow the representation of defendant Eric Smith in Uolani Gavea et al. Versus Rick Blangiardi et al. Case number 1CV-23-00378-JAO-WRP USDC be approved. The chair eighthly recommends that the request for authorization to settle claims against the City and County of Honolulu by Stephen Bose be approved. Any discussion, any objections, or any reservations to these 8 recommendations? Hearing none, so ordered. There being no further business, this meeting is adjourned. Thank you.